Good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question on offer, acceptance, and counter offer. The video content has been made available for information and educational purpose only. Kindly go through the disclaimer. Let's start with the problem question. On Tuesday, Arya tell Boo, a workmate, that she is selling her car which is worth about £2,000. On Wednesday morning, boost the email area that will take care of the car for £2,000. Will pay you when I see you. Arya replies by email on Wednesday evening, don't be silly. I was not actually offering to sell the car, but having thought about it, you can have it for £2,500. I know you will want it, so don't bother writing back unless you are not interested. Boo is so annoyed when he read the first sentence of the Ariel's email that he immediately deletes it. On Saturday, Arya drives round to Boo's house to deliver the car and demands for the payment. We have to discuss this issue. And would your answer be differ if, after reading all of the email Arya sent on Wednesday evening, Boo decided he wanted to buy the car for £2,500 and Arya now refuses to deliver it? We have to discuss in two different scenarios. Arya's statement on Tuesday that she is thinking of selling her car, which is worth about £2,000, is a preliminary indication of interest rather than a definite offer. In Gibson versus Manchester City Council, it was held that a statement inviting a negotiation does not constitute an offer. Arya's language here is ambiguous and would likely be interpreted as an invitation to trade and not an offer. In other words, the statement is not an offer, but rather an invitation to treat, a mere indication of willingness to negotiate or discuss a sale. In Gibson versus Manchester City Council in 1979, a communication stating that the council may be prepared to sell a house was held to be an invitation to trade and not a definite offer. Similarly, Aria's vague expression of intention does not constitute a binding offer to sell the car for £2,000. Here, Aria's statement was too vague and uncertain to be an offer. It did not show the intent to form a contract and lacks essential terms. Hence, Aria's statement on Tuesday was merely an invitation to trade and not an offer. Therefore, at this point, Arya has not made an offer that Boo could accept. What about the Wednesday morning email from Boo? Boo email Arya will take the car for £2,000. Will pay you when I see you. It can be considered an offer to purchase the car for £2,000 as it proposes a specific terms. This email constitutes a Boo's offer to buy the car at a specified price and is distinguishable from an acceptance because no prior offer was made by Arya. Based on the case law, case Hyde versus Branch, an offer needs to be accepted exactly as it stands. Any modification or counteroffer constitute a rejection of the original offer. Since Boo's email was an offer rather than acceptance, Arias would need to accept the specific offer to create a contract. However, she does not do so. An offer is a clear and definite proposal made with the intention that it will become binding upon acceptance. Refer to the case of Storer versus Manchester City Council. So the Boo's email meets this criteria as it proposes specific terms, price, and the payment, and reflects a Boo's intention to enter into the binding contract. In other words, Babu's response will take care of £2,000 indicates his willingness to purchase the car. But because Ariel's previous statement was not an offer, Boo's response functioned as an offer rather than an acceptance. An offer is a clear expression of willingness to be bound by terms as established in Hyde versus Range, where it was emphasized that an effective offer must be unequivocal. A Boo's email on Wednesday morning meets these criteria, presenting a clear price of £2,000. So, to conclude, Boo's email constitutes an offer to buy Aria's car for £2,000. What about the Wednesday evening Aria's email? Aria responded saying that don't be silly. I was not actually offering to sell the car, but having thought about it, you can have it for £2,500. I know you will want it, so don't bother writing back unless you are not interested. So the first sentence, Aria clarifies, don't be silly. I was not actually offering to sell the car. The statement, you can have it for 2,500, is a counter offer. The second statement, this counter offer rejects the Boo's offer of £2,000 and proposes a new term as per the Hyde versus Range. By rejecting Boo's offer and making a counter offer, Aria has not accepted Boo's original terms. So Boo's frustration and subsequent deletion of the email reflect that he did not accept Aria's counteroffer. In high versus range, a counteroffer terminates the original offer, making it unavailable for later acceptance. In other words, this is not an acceptance but a counteroffer that terminates Bo's original offer. According to the Hyde versus Range in 1840, a counteroffer extinguishes the original offer, and once the counteroffer is made, the original offer can no longer be accepted. So, the Arias email clearly rejects Bo's offer of £2,000 and proposes new terms, that is, the sales price of 2,500. The language, don't bother writing back unless you are not interested, resembles a situation in Feldhaus versus the Bentley in 1862, where a silence was not considered an acceptance of an offer. Silence or inaction cannot generally constitute acceptance because it would lead to an assumption that an unwilling party was forced into a contract. Therefore, Abu was not legally obligated to respond, and his failure to reply cannot be construed as acceptance of Arias' counteroffer. In other words, under Hyde versus Range, a counter offer nullifies the original offer, preventing Boo from later accepting his own initial £2,000 proposal. Arias' message was clearly a counter offer as it introduced a new term and explicitly indicated her non acceptance of Boo's original offer. So Arya's statement does not change this classification as the First House versus Burnley confirms that silence or a lack of response does not generally constitute an acceptance in contract law. Arya's response is a counter offer of £2,500, which cancels Boo's 2,000 offer and opens a new term. Since Boo deletes the email without responding, there is no acceptance of Aria's counteroffer for £2,500. This means no contract has been formed based on the initial interactions. What about the fourth action, Boo's deletion of the email? Boo's act of deleting the email without reading Arya's offer in full indicates he has not communicated an acceptance. While Boo may have reacted emotionally to the initial lines of Arya's email, his failure to respond or express intent means no acceptance of the 2,500 offer was communicated. Under Feldhauser's Bentley, acceptance must be clearly communicated to the offerer, and the silence or assumptions cannot bind the parties to a contract. As Boo did not communicate acceptance, no contract was formed at this point. Deleting the email has no legal effect on the contract formation process. His action indicates that Boo has not accepted Ariel's counteroffer since no acceptance was communicated. There is no binding contract at this point. The fifth action, Ariel deliver the car. When Arya drives to Boo house on Saturday to deliver the car, she might be assuming that an agreement has been reached. However, as Arya's counteroffer of 2,500 was never accepted by Boo, no contract was formed. Without a meeting of the minds on essential terms, there can be no enforceable agreement as per Feldhaus versus Bentley. Further, the acceptance must be clearly communicated. Silence or inaction does not amount to acceptance. Therefore, a boo is not obligated to pay for or accept the car as he never agreed to Aria's terms. For Arya to demand payment, Wu would need to have communicated the acceptance of the 2,500 offer. Without this acceptance, Arya's delivery does not alter the absence of the binding contract. So Arya cannot compel Wu to accept the car and pay 2,500 as no valid contract was formed. In other words, Aria's acts of delivering the car could be seen as an offer by contract. But since Wu did not accept her counter offer for £2,500, Aria has no legal basis to demand the payment. A contract requires clear acceptance, and Wu's deletion of this email shows that he did not accept the counter offer. What about the sixth activity? If Boo decides to accept the counteroffer after reading the entire email, if Boo reads the Arya's entire email letter and then attempt to accept the 2,500 offer, a valid acceptance could potentially form a contract, provided it was communicated to Arya in a timely manner. In Rust versus Abbey Life Assurance Co. Limited, the court emphasized that acceptance must be clearly communicated to the offerer to finalize the contract. Here, Abu's later decision could be considered acceptance if he notifies Arya. If Arya refuses after Boo accepts the 2,500 offer, then she would be in breach of contract. Boo could claim for specific performance or damages for the breach, as the acceptance of her counteroffer would have formed a valid contract. If Boo later communicates acceptance of the 2,500 offer, a contract would be formed, and Arias' refusal to deliver the car would constitute a breach, entitling Boo to a potential remedies. In other words, a contract would be formed if Boo properly communicates his acceptance of the 2,500 counteroffer according to the mirror image rule from Hyde versus Range. Boo's acceptance must exactly match the terms of the area's counteroffer. If Boo reads the email, reflects on it, and communicates an unequivocal acceptance, a binding contract is created at that moment. If Arya refuses to deliver the car after Boo's acceptance, she would be in breach of the contract. Boo would then have the right to claim damages for Arya's failure to deliver the car, as acceptance has created a legally a binding contract. In Rust versus Abbey Life Insurance Assurance Co. Limited, if an offer is made and the offeree acts in a manner that clearly indicates acceptance, the contract is binding. In Feldhaus versus Burnley, communication of acceptance is necessary unless a prior contract suggests otherwise. In this case, Boo explicitly acceptance would satisfy the requirement for agreement, and Ariel's refusal would constitute a breach of contract. To conclude, Aria's initial statement do not constitute an offer. Boo's early response functioned as an offer that is subsequently countered by Aria at £2,500. Since Boo deleted Aria's counteroffer without responding, no acceptance occurred and no contract was formed at this stage. However, if Boo later decides to accept the 2,500 offer and communicates this to Aria, a contract would be formed, and any refusal from Aria would result in a breach of the contract. In the initial scenario, there is no binding contract due to lack of acceptance, making Aria free to keep the car. In the alternate scenario, Boo acceptance of 2,500 counteroffer forms a contract obligating Aria to deliver the car. So the original scenario, there is no contract is formed. Aria's initial statement was an invitation to trade. Boo's email was an offer. Aria's reply was a counter offer, which Boo did not accept. Therefore, Aria has no right to demand the payment for the car. In the alternative scenario, if Boo later decides to accept the counter offer of £2,500 and communicates his acceptance, a binding contract is formed. Aria's refusal to deliver the car would constitute a breach of contract, entitling a Boo to claim the damages. Thank you.